marijuana statutes versus marijuana decisions out of the judiciary. On the most fundamental level, marijuana statutes are binding statements of law drafted by the legislature. As statutes pertain to judicial decisions, the legislative supremacy of the statutes will govern over common law decisions. Therefore, statutes are generally more powerful than judicial decisions. Let's say a hypothetical marijuana entrepreneur is confused about the legal status of marijuana in his home state and wants to get a better sense of what he can and cannot do with the plant. What's the first step? While it might be tempting to go straight to relevant case law, it would be far wiser and more prudent to first see whether or not any statutes exist. Especially because in the marijuana industry, unfortunately, there isn't that much case law to turn to. If there is a clear law already in place, written on the books, the marijuana entrepreneur's investigative process stops. And theoretically, he need not look to the existing case law, if it even exists, to better understand precedents for his case. So is marijuana legislation better or clearer than marijuana case law? Well, here are some of the advantages of on-the-books marijuana law or marijuana legislation. First of all, it's important to remember that the industry is new, and case law is a function of cases that, of course, have happened. Because of the novelty of the industry, there just isn't that much case law to refer to. But beyond that, the central advantage of establishing a marijuana law, for example, zoning rules dictating where cannabis dispensaries can be located, is that the law is a clear expression of what is or is not permissible. It provides full and transparent notice. One need only look up the code number to see what is or is not allowed. Indeed, the fact that there is much greater linguistic specificity in a statute than in case law allows us to tease out principles in a firm and objective way. Approaching a legal problem through statutes is quite different than approaching the very same problem through common law or case law. Statutes, by their very definition, possess a keenly calibrated level of detail that common law cases tend to miss. It's simply easier to determine what each party's obligations are just by looking at the statute, assuming that it was written in a clear and coherent way. Furthermore, the process of developing a marijuana statute is quite different and arguably more democratic than case law. Under case law, the plaintiff and the defendant are quite literally shaping the nature of the dispute and therefore the resulting law. Here, the parties are actually determining the questions, the arguments, and in many respects, the legal outcome. This is the essence of case law. Conversely, legislative hearings and their subsequently proposed statutes are subject to the views and opinions of hundreds of lawmakers. This notion of input by democratically elected officials is tremendously compelling and allows for a legal system that is truly governed by the people. The reason why judicial activism, where judges create rather than interpret law, is such a negative charge is that the judges are not elected by the people. Indeed, judges are supposed to be above and immune to politics. And one way to ensure that this is in fact the case is just by leaving the lawmaking up to the legislature. If lawmaking is up to the judiciary, the democratic process will be ultimately subverted. Okay, but some of the disadvantage of on-the-books marijuana law. The common law is much more context specific, and because it is so challenging to view marijuana laws in a vacuum, it is not difficult to imagine why it would be preferable to look to the case rather than statutory law to get a better understanding of the rules. Unlike legislative laws, judges have the option of tailoring the law according to the circumstances of the marijuana case. Such a case-specific analysis will allow for a fairer and more complete understanding of what the cannabis law actually is. Statutes are simply not as flexible or dynamic. Finally, the legislature's duty to provide sufficiently clear and reliable law means that the law must necessarily be inadequately tailored to each and every individual. Conversely, courts have very constrained methods for allowing and processing the facts of the case. Indeed, the judicial process allows the parties to decide which facts or evidence are introduced, and therefore the law will be tailored accordingly. Because the judicial process focuses specifically on the outcome of a specific case with specific issues, The law suits the parties in a very personal and relevant way. This is complicated stuff, and if you enjoyed this video and learned even a little bit, subscribe below. Our Cannabis Legal series is only growing and expanding, and we would love for you to be a part of it and grow and expand with us. Till next time.